Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 67th lecture series. We have gathered here to discuss about one of the leading cases mentioned in the AOR examination, Advocate on Record examination. It is our regular practice. Before moving on to the topic, we always recite preamble of the Constitution of India, because we strongly believe that our preamble, our identity, our preamble, our dignity, preamble, our goal, and preamble, our soul. So with this sentiment and commitment, I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, before moving on to the topic, let us have an inspiration from some mentors or greatly people, great saints, the quotation which gives us immense strength. So, we have seen Swami Vivekananda's quotation, and Swamiji talked about what is the purpose of education. According to Swamiji, the purpose of education, it is not mere reading books or accumulation of knowledge. That is not the education. The education which enables us to serve as an instrument for the masses, to uplift the masses' life, and to character building. Character building is very important. Once character building of an individual is equivalent to national building. Because individual, a collective of individuals is a society. And society is nothing but forming country. So individuals' commitment, individuals' character building, and individual strength, that is most important. So the purpose of education here is, we are all preparing for an Advocate on Record examination. Once we clear this examination, whether our dream got fulfilled, our dream begins thereafter. You are given an authority to plead and file it on behalf of the clients in the highest court of the land. That is what the authority, you get it. But your role play comes after you become a successful Advocate on Record. How many cases you fought for poor clients? How many cases you dealt in pro bono? How many people's tears were removed by your immense help by playing a role of a effective legal practitioner? That is the real purpose of education, dear friends. So by taking the guidance from Swami Vivekananda ji, because words are there, his vision is there, but his vision will become a life only when we practice it. In everyone's life, we have to practice it. That is most important, dear friends, and that is the purpose of education. It is not mere accumulation of facts. That is not at all. So with this quote, let us start with what is the leading case that we are going to discuss today. Leading case number, serial number 80 of the revised AOR notification, which deals with SITA Soren versus Union of India. In this lecture, 67th lecture, I will be giving you the overview about the entire judgment. And in 68th lecture, after half an hour, I will be taking you to the relevant portions of the judgment. Therefore, we can identify what are the issues and what are the ratio decidente propounded by our honorable judges. Now, the overview of SITA Soren cases, it is serial number 80 of the revised notification. SITA Soren was a member of a legislative assembly in the state of Jharkhand, and there were 2 seats for Rajya Sabha. They need to elect 2 candidates for the Rajya Sabha seat, for which a person approaches SITA Soren that I give certain amount. He is trying to give a bribe to SITA Soren with the understanding that you accept the amount, in return you vote for me. So the allegation against SITA Soren was that she has accepted the bribe. She has received the amount. In return, what she is supposed to do? She has to cast a vote in favor of the bribe giver, which she has not done so. She has voted for a candidate in her own party. So the terms broken by SITA Soren. Now the bribe giver, he is aggrieved. We have given the amount, but in return we did not receive a vote. Therefore, complaint was made. Charge sheet was filed against SITA Soren. Now she approaches the High Court of Jharkhand for quashing of the criminal proceedings against her by relying on 2 aspects, dear friends. Before Honorable High Court of Jharkhand, SITA Soren has made 2 submissions, mainly on 2 submissions. One is she has claimed privileges because a member of legislative assembly has got certain privileges. Therefore, she cannot be prosecuted by the criminal court. That was her first submission, by relying upon 2 provisions of the constitution, that is Article 105 clause 2 and 194 clause 2. Second aspect which she put forth before the Honorable High Court was, she relied upon a constitution bench judgment decided by Honorable 5 judges in the leading case called P.V. Rao versus CBI. It was reported in 1998. Why she relied upon? Reason is, there the majority has held that there are certain privileges applies to the member of the parliament as well as to the member of the legislative assembly. Therefore, there cannot be a criminal case against them. So they enjoy certain privileges. So therefore, she relied upon P.V. Rao case. But the Honorable High Court of Jharkhand, by considering her submissions, they dismissed her petition, meaning thereby criminal proceedings will continue against SITA Soren. How they have distinguished? P.V. Rao case will not be applicable in the case of SITA Soren. They have distinguished by saying, in P.V. Rao's case, at that time it was governed, there was a minority government led by Congress party. No confidence motion was introduced against the minority government to dissolve the government because they have lost confidence of the people at large. So no self-confidence motion was moved. The allegation against the minority government by saying that they bribed certain members to vote against no confidence motion. So no confidence motion was defeated by bribing the voters. Therefore, the minority government sustained. That was the allegation. But in P.V. Rao's case, the Honorable Supreme Court has held that a person who has received the bribe and voted in his favor. Therefore, he enjoys the privilege. So, the Jharkhand High Court is distinguishing how P.V. Narasimha Rao case is not applicable to SITA SOREN is, in P.V. Narasimha Rao's case, the person who has got the bribe and he voted in favor of the person who gave the bribe. But in SITA SOREN case, though she has taken the bribe, she did not vote for the person from whom she has taken the bribe. Instead, she has voted for a person appearing from her own party. Therefore, you cannot claim the privileges. Therefore, P.V. Narasimha Rao case is not applicable to her case. Hence, they dismissed her petition. Hope it is clear, dear friends. Thereafter, a criminal appeal was preferred by SITA SOREN. The matter came up before two judges bench, division bench of the Honorable Supreme Court. The Honorable Supreme Court, by considering the importance of the issues involved, because substantial question of law is involved, because the Honorable Supreme Court has to interpret what is Article 105 Clause 2, 194 Clause 2. So, they felt it involves a substantial question of law and the questions concerning general importance. Therefore, as a two judges, we will not consider, we will refer it to three judges bench. So, the matter went to the three judges bench. The three honorable judges, they have said that we are going to question to check the correctness of P.V. Narasimha Rao case, which was led by 5 judges. We are only 3. Therefore, we cannot decide. Let it go to the 5 judges bench. And the 5 judges bench has said, if you want to reverse, if you want to modify, it has to be a larger bench than the co-equal strength. Therefore, matter went to 7 judges bench. So, 7 judges bench has decided this case, SITA SOREN case, dear friends, on questioning the correctness of P.V. Narasimha Rao versus CBI case. So, this is how the matter went before the 7 judges bench. Now, what are the issues involved in this case? The issues involved is, first and foremost, one of the objections raised by the other side was that this is against, by considering P.V. Narasimha Rao case or by revisiting that case, it amounts to violation of principles of stare decisis. That is the first objection. What is stare decisis? We have to stand by the decision taken. So, whatever the settled proposition of law, whatever it is interpreted by the 5 judges, and it was held somewhere in 1998 and it was holding the field for several years, what is the need to unsettle the settled principle of law? So, therefore, don't revisit P.V. Narasimha Rao case. So, that was one of the objections raised by the other side in this case. But the answer given by honorable judges was, 7 judges was, certainly Constitution bench is meant to propound the law, is to settle the proposition of law, to ensure there should be a certainty, there should be a consistency, and there should be a continuity of the settled principles. That is the general rule. But what is the exception? Why do we want to revisit P.V. Narasimha Rao's case? The reason is, if a judgment, though maybe 5 judges bench, if it is based on unsound principles, if it is based on unsound principles and goes against the public interest, illegality cannot be perpetuated, dear friends. Illegality or irregularity cannot be perpetuated for several years. So, it is better to stop there. It is better to revisit there and propound a new law and to lay down a correct law. So, that was the reason by saying that by revisiting P.V. Narasimha Rao versus CBI, it is not violation of stare decisis. It is only reconsidering and propounding and laying down a good law. So, that is the reason, because in order to avoid illegality being perpetuated year after year. So that was the first submission, dear friends. The second aspect is whether do we have the privileges, that is parliamentary privileges. What is that parliamentary privilege? Whether do we have that privilege? Yes, our member of legislative assembly, that is MLA, MP is member of parliament, they have got certain privileges. What sort of privilege we are talking about, dear friends? Article 105, which says that, I will be taking you to the relevant portion. 105 of the Constitution of India, which deals with privileges of MPs, and equivalent to that in state legislative assembly, it is 194. So what do they say? When they are in the parliament, parliament is a temple of democracy. Will of the people is being reflected in the parliament. So those who are there in the parliament, they are representatives of millions and millions of people, and an opposition may raise a voice against the mighty government, and they should not be afraid of any legal consequences. So therefore, freedom of speech and expression within the legislative body, they enjoy absolute right. So they can express their speech, they can express by even way of voting. So that is an extended expression of freedom of speech and expression. So they can do so. So they have a freedom of speech. Why? Reason is an individual can question the higher authority by saying that you have not done to my constituency. So he should be in a position to discharge as a legislative member without fear or favor. He has to raise his voice for the aggrieved people. So therefore, he has certain privileges. Against his speech, there cannot be any complaint made in the criminal court. His speech cannot be questioned in the court of law. So that is one thing, dear friends. Secondly, the legislative members has to act in such a way to maintain the functioning of the house, smooth functioning of the house. That is so much important, because parliament is nothing but deliberation, debate, discussion, and then ultimately what is the object? Object is to give the best to our people at large. That is most important. So this is what the privileges given to them. To what extent they can claim the privileges? Individual can claim a privilege by saying that we have a freedom of speech without fear or favor. And then second aspect is, for collective functioning of the house, for smooth functioning of the house got the privilege. So if there is something happens, a contempt can be issued by the speaker, can be called for breach of privilege. So they can take action. So therefore, they have got in-house proceedings against the members. So this is what the privileges that they enjoy. But ultimately, whether the question is whether bribery, accepting the bribe for giving a vote, or for not raising his voice, or to focus on certain agenda, whether do they claim the privilege? Whether privilege is available to a person who receives the bribe and then say it is my privilege, nobody can question me. The answer is no. You cannot claim privilege when you are acting against the public interest. It's an offense under Prevention of Corruption Act. Once you accept the bribe, offense got committed. So therefore, whether you vote in favor of a person from whom you have taken the bribe, or you have not voted, that is secondary, that is immaterial. Results are immaterial whether you vote for him or you don't vote for him. That is not a consideration. The consideration is, have you received the bribe? That is an offense. For that, you cannot claim privileges. Then who has an authority to take action? Who has an authority to take action? The Honorable Supreme Court has held houses as well as the criminal court both have a parallel jurisdiction to decide this issue. So in this case, SITA SOREN was facing a criminal cases which is pending before the criminal court. So therefore, that is correct. That cannot be quashed by saying that I have a privilege. In addition to that, the Honorable Supreme Court has held, you are in public life. You should be a man with integrity, with honesty, and you should be a role model for others. And you don't say that I have received the bribe, therefore I have the privilege. Don't commit illegality and then don't claim the privilege. Privilege is given to raise your voice for the people at large in the house. It is not for the benefit of your own house. You are receiving money. House means parliament. House means legislative assembly, not your own house. So don't receive the bribe, and you should be above from all doubts. You should be a man of integrity, character, honesty. That is what required in the public life. And don't misuse the privilege. So this is what the Honorable Supreme Court has held. So this is ultimately in P.V. Narasimha Rao's case was overruled by saying that in Narasimha Rao's case what happened? They have received bribe and voted in favor of the person who has given the bribe. But in this case they have said whether receiving the bribe itself an offense, and whether you vote for him, you don't vote for him, it is irrelevant. Ultimately, you cannot claim a privilege by committing an offense. So this is what they have held in this case, dear friends. So what we have discussed is an overview of the entire judgment. Now keeping this as a guiding light, I will be taking you to the lecture number 67. Thank you so much, dear friends. Thank you.